All right, well, thank you so much for having us. We're really thrilled to be here. My name is Stephanie Pitcher. I am a representative for House District 40. Those are communities in Salt Lake City and Mill Creek. And I also work as a deputy county attorney in Davis County.
I'm Keisa Williams. I'm an associate general counsel at the Administrative Office of the Court, and I staff the Judicial Council's Standing Committee on Pretrial Release and Supervision.
Okay, so to start off with HB206, this bill addresses pretrial release practices in the criminal justice system, as well as makes some changes to the way that, or the obligations that are placed on bail bonds agents. And Bob asked me as one of the things to include in this presentation, he asked for a little background on HB206. And so I thought I'd talk a little bit about kind of how this came to be, what brought it to my attention. And first, I think when we think about the legislature, nobody sums it up better than Pat Bagley. These are a couple of my favorites. I think this one was inspired after the overturning of, or tinkering of, a few ballot initiatives. But during my first term, it's been really interesting to kind of get a sense of how the legislative process works, working with different stakeholders, understanding an issue, and then working with so many different people to make sure that it's going to work for the counties, for prosecutors, for the courts, for public defenders. And in this case, it really was a very collaborative process. So as I started thinking about issues of pretrial release, I realized that in 2016, there was actually a bill that was introduced in the legislature. It was HB202, introduced by Senator Hilliard. Representative Hutchings was his House sponsor. And it was largely the same as 206 in a number of ways. It talked about using the least restrictive conditions, also made changes to the obligations on bail bondsmen. And so HB 206 isn't a new idea. This is something that the legislature has looked at previously. After that, after SB 202, which passed its first committee hearing, but then it was held in the Senate, the legislature did an audit on the monetary bail system, and that came out in January of 2017. Before that, there was a report by the Utah Judicial Council, which talked about pretrial release and supervision practices. And I've sent that link to Bob, so hopefully he can send it out if anybody's interested. I wish I could take credit for the ideas in HB 206, but everything in the bill came either from this report to the Utah Judicial Council, the audit on the monetary bail system, and then SWAP actually had a few ideas that we incorporated as well.
Like Stephanie said, I mean, this has been a ramp-up idea across the country. Case law has been emerging in the pretrial arena for a number of years, and it's interesting to me that it's sort of been come to a head lately in the last 2 or 3 years, because I think these concepts aren't new. The U.S. Supreme Court addressed these back in the 50s with Stack v. Boyle, and in 87 with U.S. v. Salerno, which I think is a quote that we all hear over and over in our society. Liberty is the norm, and detention prior to trial or without a trial is the carefully limited exception. There are a couple other quotes that I included in here. I put a lot of slides in here about case law, and I don't want to read all of them to you, but I wanted you to have an idea, have a sense of what's out there and why the bill is so important. The bill really gets us in line with what case law is already out there. So there's been a big influx of cases in state courts and federal courts. It's been interesting because in most jurisdictions, litigants will file in federal court and very quickly get a preliminary injunction, because the federal court doesn't use money, and they haven't used money for quite a long time. And so the idea of bail schedules and charge-based bail schedules and monetary bail without considering someone's ability to pay doesn't make a lot of sense to them. And so very quickly they say, yeah, that's clearly unconstitutional, and they're granting preliminary injunctions just in nearly every case. A lot of times what's happening is the states or counties, they're suing sheriffs, counties, cities, and also their local court systems. And most of them, after the first 4, 5, or 6 cases all came down the same way. States and counties and governments started getting wise, and they would just, as soon as they got sued, they would say, wait. In mid-litigation, they would try to revise their pretrial reform laws mid-litigation, which was, I don't think that's something we would want to scramble to do. I'd like to, it to be a thoughtful, deliberative process so that we're able to build a system that works. And so thankfully, Stephanie was forward thinking, was able to get that passed so that we could, all of the stakeholders could come together and talk about how to make this work, how to do it to where it makes sense. So a lot of the case law is saying about bail schedules is they're not unconstitutional per se, they're just unconstitutional as applied because they don't provide an individualized assessment about someone's ability to pay, and they don't provide an individualized assessment about that person's risk. So they also talk about operational efficiencies. A couple of the court cases, I don't think it's one that I briefed here, but a couple of the courts said, they said, well, we don't have resources for pretrial services. One of the courts said, we don't have enough judges. We don't have enough staff to have court within 48 hours, to do an initial appearance within 48 hours. And the federal court said, doesn't matter. None of that justifies violating someone's constitutional rights. So that hasn't been.
I guess pull the mics a little bit closer.
Are we talking too quiet?
I'm talking too quiet.
Sorry. So this idea of a sub rosa detention order came up in a couple of the cases. And basically what they're saying is, if you're setting an amount, if you're in a right to bail state, which Utah is, right? You have a right to bail, meaning release. The only time a court can hold someone without bail is just those very limited charge-based circumstances outlined in 77-2-1 sub 2. Most of them are felony on felony, when someone's out on probation or parole, those types of things. And so if someone's otherwise eligible for release, they're entitled constitutionally to release. And you're setting a bail amount, which is what we've been doing for a number of years. I'm concerned about that this person may pose a safety risk. They don't qualify for a no bail hold, so I'm going to set a bail amount at $2 million with the express intention that the person be detained. That is an unconstitutional deprivation of their due process. And that's essentially a sub rosa detention order, because it's no longer a release order, it's a detention order. And sure, you can do that, but only after they're entitled to a due process hearing with right to counsel, right to present evidence, all of those things. So those are the sorts of things that we have to think about as we move forward with HB206. And it's something certainly that our judges and the court has been thinking about for quite some time. As Stephanie mentioned, we've been talking and thinking about this since 2015. We're so happy that she kind of moved us forward. Money bail, I think it's very clear that we all know money bail, there's no logical connection between money bail and protecting the public. So there is some theoretical, rational relationship between money and appearance in court, because the person has some incentive, right? There's some incentive for them to get to court. Otherwise, they lose money or have to pay money, or they lose collateral. But risk, two individuals who have otherwise the same offense, same charges, same seriousness, and even someone who's wealthy who poses a greater risk to the public safety can get out, can be released days or weeks or months earlier than someone who's indigent. And I think that we all know that's just doesn't meet our sense of fairness here. So I don't want to go through all of that. So all of the cases that I just outlined separately are not on this list, and this list is not exhaustive. These are all the cases across the country that are addressing this very issue. Some of these are resolved, some of these are still pending, some of these have settled. They changed the law mid-litigation and they've settled, but there's more. I got tired of writing them down. There wasn't a lot of room in the slide, so this isn't everything. So it's getting to become very settled. And then there is a case, there's some forward movement in the state of Utah, grumblings about filing a suit here. And I think we were saved from that with Stephanie's HB206. Primarily what the cases are finding, just a few things. Reasonable pretrial release decisions must consider a defendant's ability to pay, be individualized, be least restrictive. Charge-based bail schedules are unconstitutional as applied, and the way we were using ours, it would have been unconstitutional. Due process guarantees apply, to pretrial detention decisions. So they're entitled to a due process hearing. You're going to detain them, and then operational efficiencies are insufficient. So this is just Harris County, Texas. This was a pretty significant case in the pretrial arena. It was one of the first, and they several of the judges fought it. They sued the court, they sued the judges, the county, the sheriff, and they fought it. They spent millions fighting the suit, appealed it. And then ultimately, all of the judges who were fighting the suit lost their elections in the middle of the litigation. The new judges were elected, and they said, we're not going to fight this anymore. Let's just start working on reforming the bill. At the end of the day, they ended up not only spending millions to fight the suit, but they spent $4 million in attorney's fees. They had to pay $4 million in attorney fees, and plus there were costs of implementing reforms. So that's why HB206 really protects the counties by bringing us in compliance with the law.
Okay. So when I think about the bill, or when I give presentations on 206, I really think of it in three parts. The first part is a new standard for pretrial release and some changes to our pretrial release practices. The second part is changes to bond forfeiture, the bond forfeiture distribution scheme and obligations on bail bonds agents. And then the third part would be creation of a CCJJ grant, which can support the counties in the creation and development of their own pretrial services programs. So we'll look at it in this order. This is an overview of essentially what the bill does and the way that it impacts practices in these areas. They're broken out later in the slide, so I'll just go over this briefly. But these should be part of the resources that we've made available to distribute out if people are interested. Okay. Actually, I think you're talking.
Yeah, so judges are now required to issue what's called a pretrial status order. That's not revolutionary. That is just their decision about whether or not to release someone pretrial, and if they're going to release them under what conditions, or if they're going to hold them, justifying why they're going to hold them. And they just have to reduce that to writing, and they have to make all of those additional, conduct an analysis, put that in, what analysis did they follow, and put their findings in the order itself.
Okay, so to start, the bill, HB206 says that there should be a presumption of OR release if the individual does not pose a flight risk or a danger to public safety. So here you can see the exact language, or the considerations that a court would look at when they're making this determination. So they release OR unless the court finds that additional conditions are necessary to reasonably ensure the individual's appearance in court when required, the safety of any witnesses, victims, as well as the public, and that the individual will not obstruct or attempt to obstruct the criminal justice process. The bill also creates a presumption of detention for individuals who are charged with either criminal homicide or any offense for which the term of imprisonment may include life. That offense must still qualify for no bail hold under existing language, 77-20-1 sub 2. That presumption is rebuttable, but the presumption should apply at the outset, including at PC review. If upon or after filing charges, the state may file a motion for detention. Again, talking about those same offenses that we just went over. If a prosecutor files for a motion of detention, a judge may delay issuing the PSO and hold the defendant in custody until after a hearing. And again, the court must find that the prosecutor's motion states a reasonable case for detention, and that detaining the defendant until after the motion is heard is in the interest of justice and in the interest of public safety. And in this stage of the proceeding, the defendant does have a right to counsel. Okay, so this, I think, gets at kind of the heart of the bill and the heart of what the case law and other jurisdictions tells us. If the court finds that OR release is not appropriate or it's insufficient, then the court must impose the least restrictive, reasonably available conditions necessary to reasonably ensure, again, these same factors, that the individual will appear in court when required, factors that are conditions that will keep witnesses and victims safe, the safety and welfare of the public, and that the individual will not obstruct or attempt to obstruct the criminal justice process. When we talk about reasonably available conditions, this language is interesting. And again, this is one of the suggestions that came from SWAP, is that there may be counties or areas that don't have a robust pretrial supervision program in place. And in that case, monetary bail may be the least restrictive condition. Now, again, it may not go so much to go to the public safety factor, but it is still a condition that may be imposed. And so it really is an individual consideration. And for a judge, they would need to know or take into consideration what pretrial release or pretrial supervision programs that county has in place.
So the Judicial Council eliminated the uniform fine and bail schedule. We no longer have a uniform fine and bail schedule. We now have two documents. We have a uniform fine schedule for purposes of setting fines, and we have an ability to pay matrix for use in setting monetary bail. Something I want to just mention as county attorneys, you might talk to your sheriffs. I think a lot of them are thinking about continuing to use the fine schedule like the old bail schedule. It looks very similar. They intend to use that to allow the bail commissioners in the jail to set bail on misdemeanors like they were doing before. I would caution you to caution them against doing that, just given the case law and the way HB206 reads. I think what is a little bit ambiguous, and the reason they feel like they have the authority to continue to do that, is the bail commissioner section of the code says that they can set bail on misdemeanors using the uniform fine and bail schedule. Technically, that no longer exists, so there's a question there, I think, about whether under the statute they have the authority to do that, but it's something that the court discourages. So just something you might want to talk to them about. When I talk to the jails, I've asked them to reach out to their county attorneys to get your advice. So you may be hearing from them on that. What the court will use now is an ability to pay matrix. I put it in the materials, but this is sort of a screenshot of it. So there are two parts of it. The chart on the left-hand side is a condensed version of the poverty guidelines. So we will look at an individual's gross household income and number of dependents, look at where they fall on the poverty guidelines, and then look to the chart on the right-hand side, and we look at their failure to appear risk score on the PSA. The PSA is a public safety assessment. It's a pretrial risk assessment tool that the court generates when we can. And so we look at the failure to appear risk score there. So if I'm in 150% of the poverty guidelines, my risk score is a 4, then the recommended, quote, affordable amount is $250. Judges can deviate from this, just like they did the old bail schedule. The old bail schedule was a guide, and judges would deviate up and down. Same thing here. And as Stephanie said, this is really a fact-based decision. So judges will look at the circumstances outlined by law enforcement in their PC affidavit, the defendant's ability to pay, the defendant's failure to appear risk score, and then any other relevant information that you might provide, or that the public defender might provide, or the defendant themselves. The reason that no monetary amount is recommended when the person's failure to appear risk score is low, it's a 1, 2, or a 3, is because we do have a presumption of OR release and least restrictive requirement. When the PSA was created, it's a statistical prediction, so it's a tool. They looked at 1.5 million cases across the country, and they looked at a bunch of different risk factors. The risk factors on the PSA are all on our website. It's all publicly available. But they're all criminal history-based static risk factors, but they followed the defendants for 2 years. And what they found were defendants who, in that study, the defendants who scored a 1, on average, they appeared 90% of the time. They scored a 2, 85%, and a 3, 80. You see a significant drop in the appearance rate from 3 to 4. That's why the money starts there. It's difficult to make a least restrictive decision when the appearance rates are so high. Understanding that statistical tool, it's one piece of the puzzle in the judge's decision. It's certainly not the only one, and these types of tools, they're not a silver bullet. They don't tell you what this individual standing in front of you will do. The individual standing in front of the judge might have been in the 10% who didn't show up. But this is just another data point. It's another piece of information for them to look at. Have you gotten any questions?
I did. So
Okay.
one question came in asking about the constitutionality of HB206 under the Utah Constitution. And so in my review of the case law, when I was in the very early stages of looking at this bill, Utah has not considered this issue yet about the constitutionality of our monetary bail system, nor has the 10th Circuit. And so I recognize that the case law that we've provided today is not binding on Utah judges, but there's also a very clear pattern. In every case that I've looked at, I'm not aware of any case that has upheld the monetary bail system as is in other jurisdictions where their monetary bail system looks quite like ours. And you might have a little more insight into that. Okay. So to answer your question, the Utah courts have not yet had cause to consider the issue. Okay, that's everything I've gotten so far.
Okay. One of the tools that we intend to use, so HB206 allows an exception to conducting that ability to pay analysis if the judges issue an unsecured bond. An unsecured bond is actually something that's been allowed under the statute for a long time. We just never took advantage of it. In the statute, it's called a written undertaking without sureties. What it is essentially an IOU between the defendant and the court. The defendant is their own surety. The defendant doesn't have to pay money to walk out of jail, but if they fail to appear in court, the court on its own can forfeit the bond, and enter a judgment in the amount listed on the bond. So unlike secured bonds, this doesn't require work on the part of prosecutors. The court does this on their own. We'll set a forfeiture hearing 30 days from the date of their failure to appear, and then there's some certain findings that the judges will have to make to forfeit the bond. But the funds for those bonds, well, we'll talk about that in a second, but I've done some research. I talked to a lot of other states across the country using these. I wanted to see if they were successful, if they really did, if they really did incentivize people to come to court, how well did they perform, so to speak. And the other states have talked about, they have found a lot of success with these, particularly for people who are indigent but relatively low risk. I found 2 research studies, and there's a link to those in the memo that I included in the packet. The research looked at all other things being equal, but they studied the appearance rates and the criminal activity rates, recidivism rates, and they compared secured bonds and unsecured bonds. And what those 2 research studies found is that secured bonds and unsecured bonds, the failure to appear rates and the criminal activity rates were exactly the same. So unsecured bonds are just as successful at getting people to court, and the criminal activity rates did not increase. The unsecured bonds performed better in the sense that they reduced the jail population significantly, which makes sense because people weren't sitting there because they couldn't afford to pay. And in the midst of COVID, I think getting people out of jail is really important. So Taylorsville Justice Court, actually, I found out when I started looking at these, has been using these for about 5 years. And in that time, they've only forfeited 2. They said, in their experience, the vast majority of defendants are so grateful for the opportunity not to have to pay that they show up. Whether or not that holds true across the rest of the state, I'll be very interested to see, and so will the judges. But it's just another tool that they can use in the right circumstances. So the rules of criminal procedure, the Supreme Court on Monday approved amendments to the rules of criminal procedure on an expedited basis. Those will be effective October 1st, and they will go out for public comment. I wanted to bring them up today just because a couple of them are somewhat big changes. For the most part, it's just things clarifying language in relation to HB206. But the big ones are Rule 4 will now require prosecutors to attempt to determine what the defendant's current address is and include it in the information. And that doesn't require some major investigation. It's talking to law enforcement. Let's encourage law enforcement to get good contact information at the jail. I put my recommendation to the judges. The judges have discretion. Nothing I say, has any sway on them necessarily. It's just I wanted to let you know, when I train on this with the judges, my recommendation to them was to carefully consider whether issuing a warrant versus a summons is appropriate based solely on an issue with contact information. If it were me, I might require prosecutors to explain in the information what steps they took to obtain a current address, even if that's just, I talked to law enforcement, the person's homeless, whatever it is, just some short statement. I would be looking for that if I were a judge before I granted a warrant versus a summons based solely on that issue. So just a heads up, some judges might disagree with me, some might agree, so you might be seeing that request from the judges in your jurisdiction. Prosecutors must also now include an SID number in the information if the defendant was arrested. The SID number is a state identification number tied to an individual's fingerprints. Every individual who is booked into jail is fingerprinted and they're assigned a state identification number. That's a unique number that never changes and it follows you forever. It also ties to your FBI number in the National Criminal History Database. This helps us in a lot of ways, and so that's something that we've asked to be included. Rule 6 will require, let's see. Yeah, so the new pretrial decision process outlined in 77-20-1 applies when judges are issuing a warrant at case initiation. So when you file an information and request a warrant, they have to issue a pretrial status order. They have to follow that decision process. It's also required when they're issuing a bench warrant following a failure to appear. 7 and 7A, I think are probably the biggest changes. Judges now must address pretrial release and issue a pretrial status order at the initial appearance. They can't delay it. Some jurisdictions are doing this anyway as a matter of course, but some jurisdictions are not. Some jurisdictions at the initial appearance it's sort of standard practice for the judges to say, no, I'm not going to talk to you about release today. You can talk to your assigned judge next week. That's no longer an option. The only exception in the rule to not make that determination is after a good cause finding on a motion for a continuance. Under the statute, there's another mechanism. If a prosecutor files a motion for pretrial detention and the judge makes certain findings, then they can delay making that pretrial release decision until a detention hearing can be held. So there's a reference to the victims' rights statutes in the rule, just as a reminder that victims are supposed to be notified of all hearings in which release may be considered. And so failure to notify a victim, just if that's like a matter of course, that I know I've been told in some jurisdictions that prosecutors will say, I need more time just every single day, every single hearing. That's probably not going to meet a good cause standard. We'll have to have something else. There may be circumstances that justify a continuance on that basis, but you're going to have to make that argument. So parties can now file a motion to modify that initial pretrial status order at the initial appearance without showing a change in circumstances, but subsequent motions will require it. The other rule changes were not substantive. Rule 41 is brand new. This covers the forfeiture and exoneration procedures for unsecured bonds.
Okay, I have another question that came in, so I'll just read it out first. How do we file a motion to detain when the judges are making their decision when reviewing the PC?
Yeah, that's a big issue, right? And I think that leads me to a comment I was going to make in the end, is, one of the things that HB206 does a lot of great things, but one of the things it doesn't do that I think is the sort of missing piece that's been missing all along, right? It's not a new issue for us. The issue that this person is bringing up is what's always been a problem for judges as well, is that they have to make that essentially a blind decision at the PC phase about whether that initial decision to release them within 24 hours. So the way it works is law enforcement on a warrantless arrest submits their probable cause affidavit electronically. Judges are on a rotation, and within 24 hours, all they have access to is the probable cause affidavit, a PSA if we can generate one, which we can't in a lot of circumstances just for data related reasons. And that's it. And they have to have that, they only have that information to make all of these findings now, which is a very difficult position to be put in if you imagine just being a judge in that circumstance. And I think we were somewhat comfortable before, and why it makes us feel uncomfortable and a little bit scared now is that before, if a judge felt icky about someone, they would just set the bail at $200,000. The person would be held until the initial appearance, when they had the benefit of looking at the defendant and the prosecutor and defense counsel, and they had a lot more information. But we know that that's unconstitutional. And so now we have to look at, what next? And I think the next step is fixing the overall infrastructure, that infrastructure issue that we have inherent in our system. And I have a lot of ideas about how to do that. If we were able to have an initial appearance within 48 hours of a person's arrest, then we would meet the requirements under McLaughlin, and we could delay making that initial decision until we had an actual substantive hearing, a meaningful hearing with both parties represented, and the judges would have a lot of information, and they wouldn't be making those sort of blind decisions without information from the victim, and prosecutors would at that point be able to file a motion for pretrial detention to say, hey, I need more time let's have a detention hearing, I need more time on this individual, it's a very serious case. That's the system we need to get to. But as you can imagine, that would be Saturday courts, maybe a holiday, and a lot of resources that the rest of it, that all of us don't have at this point in time.
Okay.
That was a long answer. I'm sorry.
No, that's helpful. Okay, so the second part of this bill addresses changes to the bond forfeiture funding scheme. So currently, up until October 1st, when a bail bond is forfeited, that money goes back into the general fund. 100% of that money goes back into the general fund. We use the general fund at the legislature to fund pretty much everything, except for public education, higher education, and transportation funding, although sometimes we dip into the general fund for that as well. Under HB206, that will change. So instead of sending all of this money into the general fund, we'll send 25% of it there. 15% will go to the prosecuting agency that incurred the administrative cost of filing for bond forfeiture proceedings, and then 60% will go to a newly created grant process called the Pretrial Release Programs Fund. Before I move on, that 15% to the prosecuting agency hopefully will work as an incentive for counties to file on their bail bond forfeitures, essentially, bringing back resources to the counties to kind of, like I said, and help cover the costs associated with it, with the filing. Okay, so this new grant program will be administered by CCJJ, the Commission on Criminal and Juvenile Justice. The fund consists, again, of money that will be funneled in, that 60% that we just talked about, appropriations made by the legislature, interest earned from the money that's in the fund, and then the fund will also accept contributions from other public and private sources. This money essentially will support, like I said, the creation and development of pretrial services programs from county to county. The programs must serve the purpose of assisting a court in making an informed decision regarding an individual's pretrial release, and provide supervision of an individual released from law enforcement custody on conditions pending a final determination of a criminal charge filed against that person. So really, it's pretty broad. And again, if you work in a county that already has a robust pretrial services program in place, you are still eligible to receive funds from this grant process to help further develop your own program. Another change that HB206 makes is changes to the secured bond grace period. This is an obligation on bail bonds companies. Previously, still today, a bail bond agent has 6 months to bring a defendant back, a defendant who has failed to appear back into court. This bill reduces that from 6 months down to 3. Plus, they still have the possibility of extending that period by 2 months. This is a change that was recommended under, it may have been in the Judicial Council's report.
Yeah, it was a legislative audit too.
Yeah, it primarily came from a legislative audit, that 2017 audit that I mentioned, that took a very close look at our current processes. And also, we ran a 50-state analysis on kind of the average time and found that in most states, the average time is 2 to 3 months.
I talked a little bit about unsecured bonds. It's not a change in the statute. We just didn't take advantage of it before. But unsecured bonds, like I said before, those are forfeited by the court. There's no action required on the part of prosecutors. You'll get notice of all of that. The forfeiture hearings will be scheduled within 30 days of the failure to appear. the good part is the funds that we forfeit will go into that same 3 accounts, including 15% to the prosecutors. So you'll get 15% on these, even though you don't have to do anything. So I think that's a win-win for you.
Okay, and then the third part of the bill talks about pretrial services, and we talked about this a little bit with regard to the money that will go into this newly created fund that will support development and creation of pretrial services programs. CCJJ will oversee this. Most of us probably have some type of pretrial services program in place. In my own kind of exploration of what this looks like from county to county, I've realized that some counties have a pretrial services program in place under their sheriff's department. Others have it kind of as an independent entity that works with the counties, or I guess is under the county. And so there's a lot of different ways that counties can implement this if we don't already have one in place.
Yeah, so they're pretty inexpensive to start and to run. They don't all have to be a gigantic program like Salt Lake County that has classes and all kinds of stuff. I always give an example of my buddy Deputy Greenwell down in Sanpete County. He's the guy. So there's one guy, and he is their probation supervisor, their drug court tracker, their pretrial supervisor. He sort of does it all. And he has a lot of success. His success rates are really high. It's a pretty inexpensive program to run, and the judges love it because they're able to release people from jail who really don't need to be there, but they're not just sort of left to their own devices. They've got somebody looking out for them. They're checking in with them, making sure that they're getting to court and they're where they need to be. The research shows that just a simple court reminder, a text reminder like you get for your dentist appointment, reduced failures to appear by up to 40%, which makes sense. I mean, I need reminders, and most of the defendants we see have never used a calendar. Their lives are not all that organized, and so it would make sense that that's the case. The vast majority of defendants who don't show up, they're not absconding to Mexico. They just didn't show up, and so reminders help. Having somebody call and check in with them helps. A lot of pretrial programs will also just check to see if the person picked up any new charges across the state, and then notify the judge if there are any violations, and notify all parties if there are violations. So I think it can be done easily, and so you can start out small all the way up to ankle monitoring and UAs and classes and treatment and all kinds of things. So I talked to a lot of the law enforcement officers across the state, and I talked to the agencies that are running pretrial programs, and kind of did an average cost comparison so you could kind of see what that looks like. And so according to the law enforcement, the sheriffs that I talked to, the average daily cost to house someone in jail ranges from $60 to $75 a day. And then the average daily cost to supervise a defendant pretrial is $5.71 a day. So that's a pretty significant cost savings. So you're getting people out of the jail who don't really need to be there. They're being supervised, and the county's saving a lot of money. So I think it's a really great alternative. I just wanted to give one example of Duchesne County. I got these numbers from Judge Chiara, who's out in 8th District, and he worked with them diligently, and the Sheriff's Office started a program, a pretrial services program. And in the first 2 years, they had about 122 participants. They saved about 6,500 inmate days, and the jail housing costs ran anywhere from $63 to $72 a day if you add in operating costs, he said. And administrative costs and capital, those kinds of things. But pretrial supervision, they do a lot. So they have ankle monitors, the administrative costs, the deputy tracker, and UAs. If you add all of those things in, it still costs less. It's $40.72 a day. And so the county saves $32 a day, even with all of those services. And so in 2 years, the county saved over $200,000. So I think this is it's a critical need across the state. And so some of the jurisdictions have stepped up and done that. A lot of them have not. And the judges wanted me to reach out and say, can we please start working together and get pretrial supervision services with HB206 going into effect? Then I think those are more critical than ever. So I just presented to the Utah Association of Counties conference earlier this morning and made the same pitch to them. And so I encourage you, reach out to me and let's start talking about that. I can give you ideas about what services, what software programs connect you with different agencies across the state.
Okay, awesome. Well, we wrapped up a little bit early. If anybody has any final questions, you can text them to me. My number again is 801-791-1124. But, go ahead.
So I have a question. Some of the changes under House Bill 206, specifically the 77-20-1 related to felony on felony. Just looking at the language appears to make it discretionary. I was just wondering how that complies with the Constitution, which suggests that it's not discretionary.
Which?
So, for example, subsection 7 of 77-20-1 says, after hearing evidence on a motion for pretrial detention, the court may detain the individual if, and it lists all the conditions. But in the Constitution it says, I guess in Article 1, Section 8, that if an individual is, so an individual is entitled to bail except, and then lists the felony on felony.
Yes.
Okay, hang on. Is your system picking up the question?
Could you hear him well? Could you repeat it a little bit? If you can.
It's a lot to repeat.
Yeah, this is a common argument that I've heard from prosecutors, and there's a
Just repeat the question though.
Yeah, I will. Certain prosecutors feel they interpret the Constitution, and that section of the code as a directive, as a mandate, as a must to judges, that if they're charged with a felony on felony while they're out on probation or parole, those things that are listed there, that the person has to be detained and the judge does not have discretion to let them out. That is not how I interpret, and I've asked all of the vast majority of the judges, and not one of them have said that they interpret the Constitution in that way. They interpret the Constitution and the statute to provide them with discretion. They have to make the findings. It makes sense, right? You have to make certain findings. They have discretion to do that, whether to detain or to release under the Constitution. So that's not a change. It's just a matter of interpretation.
But you're saying, though, if they make all those findings, they could still say, you know what, I'm not going to detain you.
Well,
may, right?
Yeah, they may.
Whereas the Constitution says, shall be entitled to bail except, and lists those provisions, right?
Yeah, but when
every judge that we have in the Second District Court in Ogden have read it as mandatory.
I asked that question specifically to them.
Yeah.
And the answer was no, I don't feel that's mandatory. If I make the findings, right? If I make those findings, then I usually will hold someone in jail.
Right.
It's just a matter of interpretation. But it wasn't a change. That's not a change in the statute.
Okay. Another question, if a defendant violates a condition of release on a Class A or B and is arrested for such a violation, what then becomes the process of determining whether and how they are released?
Let's see, one more time.
So it looks like we're talking about probation violations, right?
Oh yeah, so doesn't qualify for a no bail hold because it's a misdemeanor, right? Yeah, so it's the same process. It's the same process, and when you say violating a condition, I'm assuming, are you talking about a probation violation? Are you talking about a condition of pretrial release? If it's a condition of pretrial release, then, excuse me, they would have to go through that same decision process about how they're going to handle that. But if it's a probation violation, I think that's a little bit different. There are a lot of different variables to that. I'm not sure I have enough information to give a specific answer.
Well, and I think on that note, if someone is arrested and there have been conditions that have been placed on them and then they don't abide by the conditions, then it's the court can go back and put more stringent conditions in place, essentially to cover those same 4 factors that we consistently talk about: safety to the public, ensuring their appearance in court, safety of witnesses, and ensuring the integrity of the court process. And so, again, it's a very individualized determination, and it will be based in part on the defendant's success under those conditions. Okay, I don't have anything else. Have you guys gotten any questions?
No, that's it.
Okay, well, thank you so much for having us. I will say, as the sponsor of the bill, that I am truly very interested to hear from counties and prosecutors specifically about how implementation goes in your county, what this actually looks like. I don't think that HB206 is a fix-all. I think that the success of the bill largely depends on judges holding and detaining when they need to detain. I think this swings both ways. And I'm interested in looking at this issue kind of further down the line once implementation has taken place. And so I hope you'll reach out to me and let me know how it's going for you. And if you have any questions as well about the bill, I'm happy to be a resource.
I've been offering to do individual trainings for offices if you want to get into the mechanics of it and the practicalities of it. Also, I would just want to give a shout out to Josh Graves at the Salt Lake DA's office. He put together quite a few forms of a motion for a pretrial detention, a proposed order for pretrial detention, informations that includes recommendations about a lot of the requirements in the bill, and he is willing to share those with you. So I have them. If you want them, let me know, and I will pass them on. So thanks, Josh, for being so willing to share his work product with everyone, so we're not reinventing the wheel.
Okay.
Okay. All right, thank you, Stephanie and Keisa. And Keisa, I'll reach out to you and get those, and then I can make them part of the conference materials, and we can put them on our webpage as well.